019-00269, application of Big Rivers Electric Corporation for enforcement of rate and service standards. My name is Michael Schmidt. I'm chairman of the commission, and with me today in another location is Dr. Talina Matthews. Vice Chairman Kent Chandler has recused from this proceeding because when it was initially filed, he was with the Office of the Kentucky Attorney General and apparently gained some information about it. So, at this time, we have because this is a virtual hearing, we have some protocols and suggestions for counsel and the parties with respect to how we proceed. So let me read those first before we begin. At this time, I would normally caution attendees to please set your cellular phones to silent mode or turn them off. Due to the current state of emergency in Kentucky, the Commission is hosting this hearing via video conferencing. Since this continues to be a learning experience for everyone, there are a few suggestions I would offer. In addition to the normal courtesies regarding cell phones, these tips may help with clarity and avoid feedback issues for the video conference hearing. First, mute your microphone if you are not speaking. Attorneys, when interjecting, making an objection, please state your name so the video record is clear. If you use a phone for the audio and a computer for the video, turn off the computer audio, otherwise there will be feedback. If you are in a room with several people on their own computers, turn off the computer audio for all but one computer. Otherwise, there will be feedback. If another participant is in a nearby office, close the doors between the offices. Sound carries further than one thinks, which can cause feedback. Once in the GoToMeeting software platform, go to your settings, icon looks like a gear, to ensure the microphone setting is on the microphone you are using. There's a pull-down feature in GoToMeeting settings that will list the available microphones. Use wired headphones or wired earbuds for better sound quality. Wired is preferred because wireless devices may lose power depending upon the length of the hearing. Keep a charger nearby in case your battery runs low, and please alert the Commission if you are experiencing technology failure that prevents your participation at any time in the proceedings. Attorneys should contact staff at the previously provided cell phone number. I will say that on occasion in the few of these hearings we've had, someone will get disconnected. And if that occurs, we will stop to allow time for you to become reconnected, but you may need to call in and advise our people if you are off. The purpose of the hearing today is to take evidence in case number 2019-00269, application of Big Rivers Electric Corporation for enforcement of rate and service standards. Parties to this proceeding are Big Rivers Electric Corporation, the City of Henderson, and Henderson Utility Commission, DBA Henderson Municipal Power and Light. At this time, would counsel for Big Rivers please identify himself, co-counsel, his client, and the witnesses who are available to testify this morning.
Thank you, Mr. Chairman. I'm Tyson Kamoff, corporate attorney for Big Rivers Electric Corporation. I also have in the room with me two other in-house attorneys, Greg Mays and Cynthia Santana. Seated next to me is our co-counsel, Mike Kurtz, with the law firm of Van Kurtz and Lowry, and his associates are also in the room, Jody Cohn and Kurt Bain. We have all but one of our witnesses in the room, so our CEO, Bob Berry, our CFO, Paul Smith, the Vice President of Operations, Mike Chambliss, the Vice President of Energy Sales, Mark Akert, and the Executive Vice President of Operations, Mike Pullen. Our other witness is Jim Cobb, who is
I'm sorry,
participating.
was there some feedback or something?
Hard to hear you. That was up.
All right, so our other witness is Jeff Cobb, who is participating remotely.
Okay, thank you. At this time, would counsel for the City of Henderson and the Henderson Utility Commission please identify himself, co-counsel, his clients, and witnesses who are expected to testify in this case.
Thank you, Commissioner Smith. My name is Randall Redding, and I represent Henderson Municipal Power and Light, referred to as Hempel, and the City of Henderson, which we refer to as the city. And my co-counsel is John Hughes and Sharon Farmer, and they are not on the Go meeting link. They are watching live. They are available. I have with me the general manager of Hempel, Mr. Chris Heimgartner. I have Barbara Mall, the CFO for Hempel. I have the Reliance officer, Brad Bickett. We have by remote Chris Dawson and Seth Brown.
Thank you.
And I would ask, Commissioner, could we have the phone number? You mentioned we could call in if there was a disconnect. Do we know that number?
I emailed that to the parties on Monday afternoon. I can email it again
Hey,
now.
Mr. Nguyen, our staff counsel, says he sent an email Monday with that phone number, but he will now email it again. Is that
Yes.
correct? So if you have your a phone handy, you should get an email with the number. After we finish identifying the parties and having the phone call, Mr. Redding, if you still don't have the number, we can get it and I'll announce it so that you can have it available. At this time, would counsel for commission staff please identify himself, any co-counsel?
Yes, Your Honor. Thank you. Quan Nguyen and Ben Bellamy, who's attending remotely on behalf of the commission.
I understand there are some outstanding motions. I believe there are confidentiality motions. Is that correct?
That's correct.
Are there some that have not? And those will be ruled upon at some time after the conclusion of this hearing. If at any time it appears that a witness is beginning to testify about matters that a party considers confidential, please let us know, and that we will go into executive session or confidential session so that testimony can be heard without breaching or compromising your position on confidentiality. I saw there are also some motions by City of Henderson and the Henderson Utility Commission which involve, I guess, a motion to file amended testimony of Mr. Heimgartner, then another motion, I guess it was filed yesterday or today, a second motion to file second amended direct testimony of Mr. Heimgartner, a motion to file amended testimony of Barbara Mall, and to amend, it looks like exhibits 10.2020. Maybe it's just exhibit 10. Is there any objection to those proposed amendments?
Big River says no objection.
Okay, all right. In that case, the motions, all those motions will be sustained. Are there other motions that I have not identified that at some point need to be ruled on? Okay, I take it that there are none. I checked the record, and the notice, public notice, has apparently been given and filed in the record. Is that correct, Mr. Kamuth?
That is correct, Your Honor.
Okay. All right, at this time, we will open the proceeding for public comment. Should anyone from the public like to provide the commission with public comment, Instructions to call in are located on our website, psckentucky.gov. The phone lines will remain open for several minutes at the start of the hearing and close if there are no callers or after everyone has had an opportunity to speak. Should you call in, please state your name and address for the record before making your statement, and please keep your comments to 5 minutes or less. If there is more than one caller, please be respectful and allow one person to make a statement at a time. It should be noted that comments may always be submitted on the Public Service Commission's website at psc.ky.gov. Mr. Nguyen, at this time, are you manning the telephone there or the system?
I am, Your Honor. The line is open.
Okay, thank you. We'll wait a couple of minutes to see if anyone is interested in calling in and making a comment. Mr. Redding, have you received the phone number?
I have not, Your Honor, but obviously my staff is listening. I would assume if there's a problem that
Do you have the number? Can
They
we
will
read
be
it on
able to-
record?
Sure.
I now have it. I just received it.
I'm going to ask Mr. Nguyen to read the phone number into the record at this
Sure.
time, so if you have your pen, you can write it down.
Sure, it's 770-403-4405.
I now have it.
Okay, thank you. Apparently, there's no one who is interested in calling in at this time with a comment. So we can begin the proceeding with Big Rivers calling its witness, and after that, the City of Henderson will be able to conduct cross-examination. And after the cross-examination is completed, Mr. Nguyen or Commissioner Matthews or myself may or may not have questions, but whenever that is completed, Mr. Redding, you'll have or Mr. Kamouf and Mr. Kurtz, you'll have an opportunity to conduct a redirect examination to clear anything up that you may desire to do so. So at this time, Mr. Kamouf and Mr. Kurtz, would you like to call your first witness?
Yes, Your Honor. Big Rivers calls its CEO, Robert Berry.
Okay, Mr. Berry, will you please raise your right hand? Do you solemnly swear or affirm under penalty of perjury that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Okay. Counsel, you may ask.
Thank you, Your Honor. Would you state your name and business title for the record, please?
My name is Robert Beery. I go by Bob. I'm the president and CEO of Big Rivers Electric. Our address is 201 3rd Street, Henderson, Kentucky, 42420.
Do you have in front of you two sets of testimony, direct and rebuttal, that was prepared by you or under your direct supervision?
I do.
If I were to ask you the same questions as those contained therein, would your answer be the same?
Yes.
Do you have any additions or corrections to your testimony?
I do have two additions that I would like to present this morning. First, on September the 21st of this year, Big Rivers filed its Integrated Resource Plan, IRP. A part of the optimal plan under the base case assumptions recommend that we idle our green generating plant on June 1st, 2022 and build a combined cycle natural gas plant. That's significant because shortly thereafter, Big Rivers will close and decommission the Green Station landfill. Idling the green units on June 1st, 2022 now puts more certainty around the near-term decommissioning of the green landfill, which is one of the disputed items in this case. Additionally, in my direct testimony, we provided estimated costs for decommissioning Station 2. We have since received bids for decommissioning our Coleman facility. and they were much less than what we anticipated. The Coleman units in Station 2 are almost identical, and although there's 3 units at Coleman and only 2 units at Station 2, we expect the bids at Station 2 to be slightly higher than those for Coleman for a couple of reasons. One, for the decommissioning at Coleman, we will not be we will not be decommissioning the Coleman scrubber because that scrubber will be moved to Wilson for our environmental compliance plan. Also, there are some issues at Station 2 that make decommissioning those units just a little bit more complex, such as the 2 green units are still in operation in nearby proximity, as well as the Reed combustion turbine. So it does make it a little more complex. But we do believe that decommissioning Station 2, the bids for Coleman is probably representative of what we might see for the decommissioning costs of Station 2, and we expect those costs to be somewhere between $3 and $6 million.
Does that conclude your summation?
Yes, sir.
Your Honor, the witness is tendered for cross.
Mr. Redding, cross-examination.
Thank you, Commissioner. Mr. Berry, Randall Redding for Hempel. Before I ask you some substantive questions, is it my understanding that there will be testimony presented either through Mr. Pullum or some other Big Rivers representative that has recalculated or adjusted the amount of waste in the calculations relating to the green landfill?
We have provided, I'm not certain if Mr. Pullen will speak to that, but I believe that he will, yes.
If not, is it my understanding that Big Rivers is recalculating that to arrive at the appropriate amount of waste that's in the green landfill related to the green station that predated 1995?
That's correct. The calculations, it's been recalculated to determine the volumes in the landfill based on the operation of the green units prior to 1995, as well as prior to 95, only bottom ash and fly ash from Station 2 was going into landfill. So those numbers have been adjusted, and Mr. Pullen can speak to those more specifically.
Mr. Berry, we realize, the commission may soon, when they look at the financial data, that there is a dispute as to some revenues with the revenue associated between the time period of June of 2016 and December of 2017, which what I will call the unwanted energy revenue period.
I'm sorry, I did not hear a question there.
Let me explain that. Is there a dispute between the parties involving revenue to be provided to one or the other party between the time periods of 2016, June of 16, and December of 17?
I think there's a dispute regarding the settlement agreement that was signed in December of 2017 and payment made in January of 2018 that appropriately identifies the revenues and payments for that excess Henderson Energy.
But you do agree with me that in the 2016 filing, that Big River's application addressed what you defined as unwanted or unprofitable energy.
I believe the 2016 case resulted in identifying excess Henderson Energy that was unprofitable, but it's all excess Henderson Energy.
When you filed your petition in 2016, you defined the proceedings that are before this commission today are dealing with what is known as unwanted or unprofitable energy. That was your sworn testimony to the commission, was it not?
I have had to be subject to check. I have to go back and look. I've not looked at the 2016 testimony in preparation for this hearing today. But I will say that all energy in 2016 as well as today is excess Henderson energy. Some of it's profitable, some of it's not, some of it's wanted, some of it's not. But the only energy that should be in dispute between either party is excess Henderson energy, which is defined as the difference between their load, Henderson's load, and their actual reservation on an hourly basis.
That's the position Big Rivers takes, but you are keenly aware that Henderson disagrees with that position, are you not?
Oh, I'm aware that Henderson disagrees with that position.
And during this time period, and when the hearing in 2016 was held, you represented to the Public Service Commission that if Henderson accepted the variable cost under your request, that Henderson would be entitled to the revenue from the unwanted excess Henderson energy to offset those costs. Did you not?
Well, subject to check, but I do know that subsequent to that testimony, there was a settlement agreement that resolved all excess Henderson energy, both past, present, and future. And there was a payment of $6.25 million made to the city that resolved all of those issues.
And when the commission in 2018 issued its ruling addressing the responsibility of variable costs for the unwanted excess Henderson energy, the record before the commission represented that Henderson would be entitled to the energy, did it not?
I don't know. I have not looked at that record.
And at no time did you advise the commission that Henderson was no longer entitled to the revenue from the excess Henderson energy under your 2016 declaratory action request.
Can you repeat that, please?
At no time did you amend your testimony or advise the Public Service Commission that Henderson was no longer entitled to that revenue in your declaratory judgment action request to them.
I don't recall testimony.
If you did, would you be so kind as to supplement that into the record to this commission?
Absolutely.
And if you do not supplement that, can we assume that you did not advise the commission of that?
I don't know how to answer that, Mr. Redding.
You either did advise them or you did not.
Pardon?
You either did advise them or you did not.
And currently, at this moment, I don't recall if we did advise them or not.
And Big Rivers, during that time period of June of 16 through December of 17, received revenue of $10,696 on this unwanted excess Henderson energy, did it not?
I don't know that exact number. It is in the calculations, I believe, in this case, and Mr. Smith can speak to those numbers more specifically. But as I stated earlier, January the 4th of 2018, Big Rivers made a payment to the city of Henderson for $6.25 million to resolve all of those issues.
Well, let's talk about that thing. In your filings with the petition, you state that Big Rivers made that payment, but who funded that payment?
Big Rivers wrote that check to the city of Henderson, and it is made from Big Rivers.
Did Eon reimburse Big Rivers for that money?
Eon made a payment to Big Rivers to basically be relieved of their obligation under the indemnity agreement. And at that point, we took part of that money and we used that to settle all the excess Henderson Energy issues that we have with the city of Henderson.
Did Big Rivers reimburse you for the $6.2 million that you're referencing in your testimony? Eon.
Yeah, Big Rivers.
Eon reimbursed you for that?
Eon paid Big Rivers a sum of money to get out of their obligation under the indemnity agreement. And what Big Rivers did with that amount of money was up to Big Rivers.
How much did Eon pay you?
The exact amount was a little bit north of 10 million.
And during this disputed time period in June of 16 through December of 17, Big Rivers also sold profitable energy, did it not, and received revenue?
That's correct. We sold excess Henderson Energy at a profit during that time.
And that profit, according to Mr. Smith's testimony, is $2.48 million.
Well, I think you have to ask Mr. Smith that question. I would not want to testify to his testimony.
And under your, and the variable cost that you've presented for this time period for unwanted excess energy was $10,688,000. Correct?
Again, you'll have to ask Mr. Smith if that's in his testimony. I think he would be the appropriate person to ask those questions to.
And you remember that you were a party to the 2009 civil action, which was the subject matter of the release that you're referencing, were you not?
I'm very familiar with it, yes, sir.
And that complaint in its prayer asked Big Rivers to disgorge itself of revenues from the profitable excess Henderson Energy, did it not?
Are you speaking to the case in the Henderson Circuit Court?
Yes?
So what I recall is in that case, Henderson was seeking reimbursement or damages for excess Henderson Energy that was taken by Big Rivers, that the city had made the accusation that Big Rivers blocked them from taking that energy.
And it specifically referenced profitable excess energy, because you couldn't sue for negative, could you?
It was it was for excess Henderson Energy, which was wound up being a part of the arbitration between the parties, and it defines excess Henderson Energy as the difference between Henderson's reservation and their actual load on an hourly basis. It's the same definition that the commission used in the 2016 case. That is again, the difference between Henderson's reservation and their actual load on a given hour.
Were you aware that the civil action that was filed, its only request in the actual pleading was for the damages related to profitable excess energy for the revenues that Big Rivers had received? It's yes or no?
I can't speak to that. I don't know.
Assuming that is correct, you were aware, were you not, that the release that you're referencing to this commission was specific that the release will only apply to Civil Action 09 CI 693, hereinafter referred to as the damages suit.
Are you
The release
speaking?
that you filed, the release that you have filed with the PSC.
Are you saying, you're talking about the 2017 settlement agreement?
Yes, sir.
The 2017 settlement agreement releases all claims and settles all excess Henderson Energy claims, both past, present, and future. I was in those negotiations, as were you, and if you recall, on December the 12th, 3 p.m. in the LG&E headquarters, I was ready to get up, and got up, closed my book to walk out because you guys Henderson wanted to categorize different categories of excess Henderson Energy, profitable, unprofitable, wanted, unwanted. And I said, no, if I'm going to pay $6.25 billion, it's going to resolve all the cases in excess Henderson Energy because you've already been paid for it twice. I don't want you to take my money and sue me a third time for it. So that was the dispute. And Mr. Heimgartner and I broke out in a conference room for about 20 minutes, and we came back in, and Henderson agreed to the language in the 2017 settlement agreement that specifically says it releases and resolves all claims past, present, and future, as well as Henderson's own audited financial statements represent the exact same language that I'm mentioning to you today. That's what I know.
Mr. Commissioner, before I ask my next question, let me note my objection. I object some self-serving testimony from a hearing, from a settlement meeting. But with that said, Mr. Barrett, and I can read the release or you can pull the release. The release specifically says, this release shall relate to and be to the damages claimed in Civil Action 09 CI 093. If I'm reading that correctly, do you have any objection to that being the language that's in the release the commission will see?
Well, I think that would be subject to check because there's other language in the same release that talks about releasing all cases that you have, ever did have, or ever will have going forward. So, I think you can't take one sentence out of that agreement and try to say that that was the intent of the entire agreement.
Let's visit with the calculations of what you are presenting to the PSC, that you're asking them to accept your calculations and disregard this dispute. But correct me if I'm wrong on these calculations. You're asking the commission that you receive the $10 million in excess Henderson Energy revenue for the time period during June 16th through December of 17th, are you not?
Actually, it's my position that Hempel accepted those calculations when they agreed to be paid $6.25 million to resolve all those issues.
You're asking the commission that you be allowed to keep that revenue.
We're asking the commission to agree that the settlement agreement covers all of those issues and resolves all those issues.
And you're also asking the commission that you be allowed to keep the $2.4 million during that same time period for profitable energy, are you not?
We are asking the commission to agree that the settlement agreement, or interpret the settlement agreement, which reads that it resolves all excess Henderson Energy issues, past, present, and future. In that same settlement agreement, Big Rivers waived its right for excess Henderson Energy going forward after January the 4th of 2018, and that all excess Henderson Energy going forward belongs to Hempel, and that Hempel would pay the variable cost. And I think those are very close to the exact language that's in that settlement agreement.
And contrary to what the record reflected when the commission entered an order in 2018, you're asking for Henderson to pay the variable cost of $10 million, that Big Rivers gets to keep the revenue of $10 million on the unwanted excess Henderson Energy. And in addition, Henderson would have to write off $3.5 million of coal, are you not?
I'm asking the commission to require Henderson to honor the 2017 settlement agreement that they willingly signed and negotiated, which resolved all of those issues.
If the commission believes the release that you're referencing was limited to profitable energy, then Henderson would be entitled to the revenues to set off against the variable cost as you represented in the 2016 hearing, would they not?
Can you restate that question, please?
If the commission finds that the release is limited to the profitable energy in the 2009 civil action, then Henderson would be entitled to the revenues from the unwanted excess Henderson Energy that was the subject matter of the 2016 hearing.
So nowhere in the settlement agreement does it mention profitable energy. It mentions disputed energy and excess Henderson Energy, which is the same definition that the commission used in 2016 and the same definition that the arbitration awards in the arbitration that actually was appealed all the way to the Kentucky Supreme Court. So I think the settlement agreement is clear. It resolves all those issues, past, present, and future.
Mr. Berry, I will continue to ask this question. If the commission finds that the release that you're referencing does not apply to the unwanted excess Henderson Energy, then you will agree that Henderson is entitled to those revenues to offset against those variable costs.
Chairman Schmidt, I have an objection on the basic point that this has already been asked and answered, plus it misconstrues the release agreement, which applies to all excess Henderson Energy, not just a subset. So I object to the question.
Well, I think that ultimately we'll be receiving other testimony on this point, and it comes down to a question of interpretation. I think the question has been asked, and to the extent the witness intends to answer, he's already done that. So, Mr. Redding, we probably ought to move along. I think we understand your point.
Thank you, sir. I think that's all I have, Your Honor.
Okay, thank you. Mr. Nguyen, any questions of Mr. Berry?
Yes, Your Honor, just a few. Good morning, Mr. Berry. Can you hear me okay?
I can, thank you.
Can you refer to your rebuttal testimony, page 12 of 30, please? And
Can you repeat that page, please?
it's page number 12 of 30.
Okay.
Okay, in the middle of the page, you list certain required or mandatory decommissioning activities that will need to take place at the Station 2 generation station. and you identify some federal regulations regarding the disposal, the coal combustion residuals rule, the CCR rule, federal rule regarding spill prevention, control, and countermeasure plan, the National Pollution Discharge Elimination System, as well as the regulation on National Emission Standard for asbestos, and also Surface Mining Control Reclamation Act and the Resource Conservation and Recovery Act. Can you identify, with respect to those regulations or statutes, which facility or assets at the Station 2 that would need to be decommissioned first? Are you able to do that now, or would that be more appropriate through a post-hearing data request?
It may be more appropriate in a post-hearing data request. I could probably answer some general questions on those today.
Sure, that'd be good.
So are you asking what activity is required to comply with each one of those?
Yes. So, for instance, the CCR rule, we understand that that's going to impact the Station 2 ash pond. Are there any other facilities that will be impacted by the CCR rule?
Not that I'm aware of, just off the top of my head, but it's really, we have to close the Hempel Ash Pond, and I believe the date per the CCR rule is April of 2024. It has to be completely closed.
Okay. And then what about the spill prevention, control, and countermeasure plan?
I'm sorry, but under that CCR rule, there is also a requirement of 30 years of groundwater monitoring that is required following the closure of that plant.
Okay.
Okay. The spill prevention and control countermeasures means that any type of hazardous waste, fluorocarbons, anything that we have on site that we either needs to be removed from site, or you need to continue to maintain your spill prevention and control countermeasure plan. And I'm talking about different solvents, paints, or anything like that that's on site.
Okay, what about the NPDES?
The NPDES is really has to do with the runoff and discharge of the current ash pond, and then any stormwater runoff, coal pile runoff, those items that are required to stay in compliance within that NPDES permit. It's a specific permit, and those limits are listed on that permit.
Okay. So are there other facilities that accept those type of runoffs other than the ash pond?
Yeah, there's a coal pile runoff pond
Okay.
that receives, any rainwater, stormwater runoff from the coal pile, so that it's not discharged improperly.
Okay, so that has to be, when you say decommission, what do you mean? It has to be fully retired according to whatever the regulation provides?
If that means fully retired, and in the case of the ash pond, it has to actually be closed, capped off, and with a certain amount of soil over top of the ash, and then sown in grass.
And that will be pursuant to what the regulation would require, correct?
Yes, sir.
Okay. And then what about the asbestos standards?
Okay, so in the asbestos standard, you have to be able to, manage your asbestos, no exposure. If you do have exposure, if you have asbestos that's friable and the things become airborne, you have to basically rope off or, make countermeasures in order to keep any kind of asbestos exposure there.
Okay.
So you have to continue to maintain that asbestos. You have to walk it down, make sure there's none friable that's fallen off and that has the potential for human exposure.
Okay, so to the extent that if Station 2 remains retired in place, certain areas of the station that contains, that has asbestos-containing material will need to be, did you say roped off or segregated or contained somehow? So measures that are put in to contain activities within the area so that the asbestos, so that it wouldn't agitate the asbestos containing materials that are located in those areas.
Yeah, so you would barricade off, basically Station 2 if it's retired in place, and then someone would need to walk down the unit on a pretty frequent basis to confirm that no asbestos has fallen off the pipes or off the turbine or whatever, wherever the asbestos is located. And then if it has, then you have to take the proper cleanup measures, because, you know, if it's on a really windy day, it could actually, you know, blow beyond the barricaded area that you have barricaded off.
Okay, so the entire station has to be cordoned off.
That's correct, and it's important because we have Green Station that's adjacent to Station 2. So if, you know, we want to make sure that we don't have any exposure to the employees there in the Green facility.
Okay, and then what about the Surface Mining Control Reclamation Act? What facilities or assets will need to be addressed related to this particular statute?
And that's really cleaning up where the coal pile is located, actually removing any residual there and bringing that back to a brownfield or greenfield site.
Okay. And then the Resource Conservation Recovery Act, which facilities would be impacted by that particular statute?
I think that's one I probably need to do a little more research on to give you an adequate answer.
Okay. And then what I would also like is any projected or estimated costs associated with each one of these compliance measures related to the regulations or the statute that you've identified as well. And I'll include that as part of a post-hearing data request.
Okay.
If you give me 1 second, I'm just going to jot a note here for that. So if you could, please turn to page 13 of your rebuttal testimony, lines 21 and 22 at the bottom of the page.
Okay.
So those lines, you state that should Henderson choose to simply abandon Station 2, then Henderson must bear any resulting costs, including EPA penalties. Could you provide support for this particular statement, particularly regarding the EPA penalties that would be obligated by Henderson upon abandonment? And I guess, what do you mean when you say abandoned?
Well, what that means is if Henderson decides just to walk away from Station 2 and not provide any decommissioning, they decide not to manage and continue to maintain as if it's retired in place. In this case, specifically the Henderson ash pond or Station 2 ash pond, if that ash pond is not closed by April of 2024, there are EPA penalties that will be assessed to the owner of that pond.
Okay, so the penalties are associated, or the obligation flows from the ownership of that particular facility?
That's correct.
Okay. Were there any other EPA penalties that would be covered under this statement as well, other than, a potential violation of the CCR rule?
I mean, there could be others, such as if Henderson decides to walk away and not maintain retirement in place or decommission and abate the asbestos. If there's asbestos exposure and friable asbestos that's allowed to be released in the air, EPA as well as OSHA could have some penalties as well. Stormwater runoff, if it's not maintained properly and that runoff gets discharged to the river and it's above the KPDES permit limits, then there will be penalties associated with that from EPA as well.
And those are similar to the CCR rule in terms of the obligation belonging to the owner of those facilities as well?
That's our position, yes, sir.
Okay. And when you say that's your position, is that the position based upon your reading of the regulations or the statutes, or what's
Yeah.
that position based upon?
It's our interpretation of the regulations.
Okay. So can you turn now to page 15 of your rebuttal?
Okay.
Similar to the questions that I just asked you, lines 10 through 14 on this page, you state that the cleanup of Station 2 after its operating life was expressly contemplated in the 1993 amendments, and Henderson should be held to its contractual commitments to share in the decommissioning costs or absorb all of the retirement in place costs of the power plant it owns. Can you provide a little bit more detail and support regarding the portion of the statement in which you say that the cleanup of Station 2 after its operating life would be, the statement regarding that the cleanup of Station 2 after its operating life was expressly contemplated in the 1993 amendments?
Yes, so prior to the 1993 amendments, Big Rivers had no contractual obligation for any decommissioning costs. And I believe in the 93 amendments, if Big Rivers agreed to extend the operation agreement through the end of the useful life of Station 2, then Big Rivers would now be responsible for, and I'm going to give you round numbers, 78% of the decommissioning cost. But there's nothing in the contracts that says Big Rivers has any responsibility for retirement in place costs. It just says that Big Rivers is responsible for 78% of the decommissioning cost.
Okay, so you're saying prior to the 1993 amendments, there was nothing in the various Station 2 contracts that address or that would require Big Rivers to be obligated in any fashion with respect to the decommissioning costs associated with Station 2?
That's correct.
Okay. But with the 1993 amendments, and I think you mentioned that after Big Rivers had, was this after the extension of the Station 2 contracts?
That's correct. I think the initial contracts were to expire in 2003, and the 1993 amendments extended the contract through the useful life of Station 2. And at that point is when the decommissioning language was inserted that said the parties would share on the decommissioning costs based on the amount of capacity each party took out of that station over the life of the station. And when you do that calculation, it's about 78%. For Big Rivers and 22% Hempel.
Sure. And was the decommissioning costs, the allocation, was that something that was raised by the city, or was that something that was raised by Big Rivers in terms of, anticipating when the Station 2 would need to be retired and those costs associated with its retirement. Do you know which party, raised that particular issue?
I do not.
Okay. And okay, to the extent that you mentioned that the absorbment of all of the costs related to if Henderson decides to continue with the retirement in place, that obligation would be solely upon the city. Is that correct?
Yes.
Okay. And your support for that is that in the contract or in the amendment, there isn't any provision that addresses retirement in place. So absent that, Henderson is obligated 100% of any retirement in place costs.
That's correct. The contracts were, I believe, very clear that both parties anticipated when the end of the useful life of Station 2 that it would be decommissioned, which is why they put the decommissioning language in the contract, and why there was no language in the contract that references retirement in place.
Okay. So can you turn now to page 17 of your, I'm sorry, let me check this 1 second. I'm sorry, turn to page 23 of your rebuttal testimony. At lines 1 through 4 regarding the expansion of the Green Station landfill.
Okay.
Give me 1 second. Okay. You mentioned that the expansion of the Green Station landfill was driven by the accumulation of the Station 2 waste. Is that correct?
So it was driven by both parties, Green Station continue to operate, as well as Station 2 to continue to operate. However, had Big Rivers not been putting the Station 2 ash in that landfill since, ash and Positec since the beginning, bottom ash and fly ash since the beginning, but Positec beginning in '95 when the Hempel scrubber went into commercial operation. If all that scrubber sludge from Henderson had not been put in that landfill, Big Rivers would not have been required to put the wall in to allow some additional room in that landfill for going forward purposes.
Okay. So is it, well, on line 3, begin on line 3 to 4, your testimony, the rebuttal testimony states, but for the accumulation of the city's waste, the vertical expansion would not have been necessary. So are you saying that the expansion of the green landfill is driven directly by the disposal of Station 2 waste in the landfill? That's
correct. If the scrubber sludge from Henderson or Station 2 would not have been going to the landfill. There would have been no need for vertical expansion or putting a wall in for expansion.
Okay, and I think you touched upon this at the very beginning of your testimony in terms of any additions that you may have. And you mentioned that there are some recalculations to the amount of the Station 2 waste that is contained in the Green Station landfill. Is that correct?
That's correct. What we've tried to do is base the financial obligation from each party based on the volume of material that is stored in that landfill. And when our initial calculations were made, we did not include the scrubber sludge for the green units from the time they went in commercial operation until 1995. We only started in 1995. And so the city brought this to our attention, and they are correct, and that calculation needs to be adjusted, which will, and I think in the testimony, it was showing that Kimball's responsibility for that landfill was about 12% roughly, maybe 11.9 or something, but, and I think those new calculations takes it down to about 9.8%.
Okay.
Uh,
So you're saying that the Station 2 waste accounts for about almost 10% of the volume in the Green Station landfill currently, or is that over time?
So currently, well, I'll make sure I answer your question correctly. So that 10% means what's in the landfill today
Okay,
is about 10% of that ash came, or 10% of the material came from Station 2.
okay.
Let me clarify that,
Sure.
if I may. So there's really more than 10% of the waste in that landfill that belongs to Station 2. However, so the way the calculation works is you first see how much belongs to Station 2, and then Big Rivers is responsible for a certain percentage of Station 2. So that 10% is the amount of waste that's left in the landfill that's attributable to the energy that was taken by the city of Henderson.
Okay, so, so the total Station 2 waste, if you include the energy that was taken by Big Rivers, would be more than 10%?
Yes, sir.
Okay. Okay. And that percentage would be, the total amount of Station 2 waste would be, would you say it would be significantly more than 10%, given that Big Rivers took the majority of the energy that was produced by, more than half of the energy that was produced by Station 2?
Yeah, so the 78% obligation in decommissioning essentially means Big Rivers took 78% of the capacity of those units over the life of the station.
Okay. Can you move down to lines 5 through 9 on page 23 of your rebuttal?
Yes.
Okay. You mentioned the the cost comparison to dispose the Station 2 waste at the Green Station landfill with an off-site commercial landfill, and the savings that that was inherent in the city using this Green Station landfill. And you mentioned that the savings was about $3.1 million since 2015. So what is the comparison based upon? Was it based upon a nearby commercial landfill, or could you provide that information in terms of what the basis for that comparison was?
And so if you look at the amount of ash that the Henderson's portion of the amount of ash that went into that landfill, it's about 525,000 ton roughly. And it would be an additional $6 per ton to truck that off-site by either building a new landfill or going to some type of commercial landfill. We have looked at those pricing because when we were doing the expansion, we were trying to evaluate the most cost-effective a way of extending the life of the landfill. Would that mean build a wall, or do we build a new facility off-site, or do we truck it to our Wilson facility, which did have enough capacity for it? And so that's how we knew that it would be about $6 a ton incremental to what they were currently paying.
Is that a market price for, that you arrived at, the $6 per ton?
Well, I would call it, I guess you could call it a market price. It's essentially, the cost of either building a new landfill and managing it, along with the trucking that it takes to haul it off-site, permitting for the haul it across the highways.
Okay, so it was the derivation of that $6 per ton for trucking the waste was basically building a new landfill and trucking that off-site.
That's correct. Or taking it to a commercial landfill. I think we looked at taking it to a commercial landfill as well.
Okay. And there are nearby existing commercial landfills that would be able to take these type of waste?
There are commercial landfills. I wouldn't call them necessarily nearby. I'm thinking you're probably looking 30, 40 miles away. But I'm not certain on that.
Okay.
It's something that I would have to do some research to tell you the exact locations.
Okay, but those also fell within the $6 per ton? Fee?
Yes.
Okay. Can you turn now to page 24 of your rebuttal testimony, lines 14 through 15? And this is regarding your statement in which you said that Big Rivers would be legally prohibited from taking title to the Station 2 waste because of the nature of the Green Station landfill permit. Can you provide more explanation as to the Green Station landfill permit and why, under the provisions of that permit, Big Rivers would not be able to take title to Henderson's Station 2 waste in that landfill?
So I'll give you as much as I possibly can here. The landfill currently is permitted as a special waste landfill, and it's only for putting bottom ash and fly ash from our units in that landfill, along with scrubber sludge. If we started taking title from another party and putting their material in that landfill, then it would become a commercial landfill, and it would fall under a totally different regulation and permitting process.
Okay, so the permit itself specifies the owner of the waste that will be accepted in that particular, in the Green Station landfill, is that correct?
I don't know if it specifically says owner, but it's basically saying that you can put the waste that your plants, that you're owning or operating, what that creates, you can put that waste in the landfill. However, you can't start putting other parties' waste. You can't be paid to put other parties' waste in your landfill.
Okay.
Then you lose your special waste permit. And the restrictions on a commercial landfill are much more stringent than what they are on a special waste landfill.
Okay. Just want to switch now to your direct testimony. At the bottom of page 17 and the top of page 18. And you compare the typical residential customer rates for the city versus the 3 Big Rivers Distribution Cooperative. Okay, and you mentioned that a typical residential customer would have a monthly bill of about $84.90 for that served by Henderson. But a customer for Jackson Purchase would have a monthly bill of $117.18. Kenergy's customer, residential customer, will have a monthly bill of $120.24. And Mead's residential customer would have a monthly bill of $114.82. Do you see that?
Just one moment, I'm
Sure.
listening, but I'm getting there. This book is not meant to cooperate, so. Yeah. Okay, I'm sorry, go ahead now.
Yeah, no worries. So do you see the language where you made that comparison?
Yes.
Okay. And then you state at the top of page 18 that the discrepancy is due in part to the fact that Big Rivers has borne costs that Henderson was obligated but refused to pay. Could you provide additional information regarding this statement about the discrepancy being due in part to Henderson's refusal to pay costs that they were obligated to pay under the Station 2 contracts?
Is that something you want in a public hearing data request or just verbally or?
It's up to you. If you're able to address it now, then please do. But if you feel more comfortable addressing it more fully in a post-hearing data request, we could do that as well.
Yep, just 1 second here. Yeah, let's do that in a public hearing data response if that's acceptable to you.
Sure. And what I would like is, and I'll have this in the post-hearing data request, but if you could identify which or what obligation that Henderson had refused to pay under the Station 2 contracts that would have caused this discrepancy in the rates paid by the 3 Big Rivers customers of the 3 Big Rivers distribution cooperatives, and the monthly payment of a residential Henderson customer. Okay. Those are all the questions I have, Chairman.
Commissioner Matthews, questions?
I don't have any, thanks.
I just have 2 or 3. Mr. Berry, who at present what is Big River's position as to who actually owns Station 2? The land, the plant, the equipment?
So it's Big River's position that Henderson owns Station 2. They've owned Station 2 for 47 years, and they've made no bones about it. They have complete control of it and own Station 2. I don't want to speak for their position, but typically they think that once the units quit operating, it now belongs to Big Rivers.
Did Henderson actually build and pay for Station 2?
So the Station 2 was built using tax-free bonds through the city of Henderson. But Big Rivers actually, I guess, was paid more than 90% of the cost to build Station 2. And that's the extreme benefit that Henderson has received out of Station 2. They had a large generating unit that they were able to get economies of scale on, and they were able to grow into that without any additional capital cost up front by just increasing their reservation by 5 megawatts a year each year as we went through the contracts.
In terms of the permits, I guess that Mr. Nguyen asked about, are all those permits in the name of Big Rivers?
They are.
Are there any permits in the name of Henderson?
I'm not aware of any.
Now, the landfill that you discussed, who has legal title to the property that the landfill is on?
So Big Rivers has title to the property that the landfill is on, but the Station 2 contracts specifically state that the ash dredgings in the landfill still belong to the city of Henderson. I believe it says they're owned by the city of Henderson.
Insofar as I guess your rebuttal testimony about the difference in the residential electric rates between the city of Henderson and the 3 rural electric cooperatives that Big River serves, you indicated that in a post-hearing data request, you could provide specific information as to what those costs are or were that you claim Henderson should have be responsible for, but that Big River's paid. Is that correct?
Yes, sir.
Can you tell us, do you have some idea what those costs would be? I don't mean in amounts. The reason I ask is that I assume in a post-hearing data request, if you provide some detailed information, that counsel for Henderson might want to ask some questions about that. And I don't know, he might not, depending on what it is. But I was just thinking myself how we could do that if we don't know what those costs might be.
So I'll give you a couple just off the top of my head. One is the MISO fees, and that's part of this disputed case that we're in today. Been a lot of testimony around the MISO fees. We joined MISO. We had no choice in order to meet our NERC contingency reserve requirements. We were required to join MISO. Henderson has refused to pay any MISO fees since 2010. When we joined MISO, I think that amount is about 1.4 million roughly. We are currently being required to put a trench around the landfill, the green landfill, because when it rains, water permeates through the cover of the landfill. It runs down through the landfill, and then it runs out at the bottom of where it's piled up in the landfill, at what we call the toe. And when that water comes out, that landfill acts like a filter, except it's picking up in the water now has arsenic and might have some heavy metals or something in it. So we're required to put a trench around that landfill, capture all that runoff water, send it to a pond to be treated before it can be released. And, as we just stated, 10% of the waste is Henderson's waste. And so 10% of that cost should go to Henderson, and they've refused to pay it. And I can go on with others, but that's the kind of things that we're discussing here. And I think some of this is actually in Mr. Smith's testimony in some of those numbers and calculations he provided.
I don't have any further questions, but Mr. Kurtz, before I ask if you have any redirect, I want to ask Mr. Redding if he has any questions about this cost differential between the residential electric rates in Henderson and the 3 rural cooperatives that Big River serves, insofar as these costs are concerned.
Thank you, Commissioner. Obviously, we would need to reserve our ability, because I don't believe there's been sufficient information provided to us to properly respond to that. I guess I would have one question of clarity. Mr. Berry, at this time, it is now 2020, Big Rivers is not paying any MISO fees on behalf of Henderson at this time.
That's correct. In 2019, after the plant, Station 2 was ceased operation, Henderson joined MISO as a transmission owner and are now paying their own MISO fees, probably the same amount or more than what they refused to pay at Big Rivers for.
So your answer is you're not being charged for any MISO fees on behalf of Henderson in 2020?
In 2019 and 20, we have not been. Since February of 2019, not.
Thank you.
Anything else, Mr. Reddy?
Not on I understood your direction having been on the issue of where Mr. Wynn had asked about the subsequent data request. I may have some other questions depending on what counsel for Big Rivers asked.
At this time, it's 10:30, and so we've been going for an hour and a half, and we intended to take a lunch break at noon. So why don't we take a 10-minute break at this time, Mr. Kurtz, before you conduct any redirect that you may have. So we'll be in recess until 20 minutes until 11 o'clock. Thank you. Okay, we're now back on the record. Is Big Rivers available?
Doesn't look like they are, Chairman.
We're running out of different, yeah. Okay. Mr. Kurtz, you have a redirect examination?
Yes, sir. Mr. Berry, you were asked a number of questions about the rate differential between the City of Henderson residential rates and the rates of the three owner members of Big River. Do you recall that?
Yes, sir.
Is it, and part of it is, for the differential is cost that you believe the city should have paid, but Big Rivers has been paying?
That's correct.
Is another part of the rate differential reason that the benefits essentially that the city has received through its contractual relationship with Big Rivers over the years?
That's correct.
Would that include use of $42 million of scrubber joint use facilities at the Green Station that was used in Station 2?
Yes, that's correct.
Would it include using the green landfill at cost?
That's correct.
Would it include providing standby capacity to the city at no charge?
That's correct.
There were a number of questions about the green landfill and the number of tons that are in there. Do you recall those?
Yes, sir.
In response to a data request from staff, 1-14, is it your understanding that at the end of 2019, the city had 2,618,667 tons of scrubber sludge and ash pond dredgings in the green landfill?
That's correct.
Okay. So your understanding their position, their position is they should no longer be required to pay for storing the 2.6 million tons in your landfill.
That's been their position, yes.
And when the green landfill is retired, their position is they should not have to pay to decommission their 2.6 million tons.
That's correct.
Staff council asked you a number of questions about the environmental rules and how they apply to different facilities at the Green Reed Station 2 complex. Do you recall that?
Yes.
Is there an exhibit that you would find helpful to talk through those issues?
Yes, it's attached to my rebuttal testimony, Exhibit 1, which is actually a map of the site, Station 2 site, and as well as the green units. We refer to this site as the Seabury site.
Thank you. Is there a way to make that a little bit bigger? Because it doesn't show everything.
Let me try, Mike. Well, let's see.
Well, we can work with that. Mr. Berry, can you go ahead and
Yeah,
describe?
can you scroll down and start at the
Sure.
bottom and I'll my way up to the top? Would that work? Yeah, go on down as far as you can, please.
Okay.
Oh, there you go. Okay, so this is a good place to start. The big red circle you see on the left of the screen, outlined in red, is the green landfill. And so that kind of gives you a little bit of perspective. If you'll start scrolling back up now. If you can stop right there. So you can see the EHV switchyard to your left. That's the square you see to the left. Actually, when it's so small, it may be difficult to see. But when you look at all the equipment associated with Station 2, you can see the Station 2 ash pond is a light blue area that's encompassed to the left of the cooling tires. You can see that's the ash pond. when we talk about the property that reverts back to Big Rivers, really that's a very small piece of this whole site. So the property that has the reversion language in the deed is just those two coolant tires that you see in dark blue. And in the center there where it says H1 and H2, that's very small block, right where it says H1 and H2. So as you can see, that's the only part of the property that is covered with the reversion language. Where the ash pond's not, it's not covered. You can see bottom ash and fly ash listed there. That's not covered in the reversion deed. As you go around, you see the Reed Hempel cold storage. That's not covered in the deed. All these other conveyors that you see, I wish I had a pointer that I could show you, but all those lines that are coal conveyors, they go all the way to the river to the barge unloader, which is far right in your upper kind of right-hand corner. You see the barge unloader out in the river there. All of that is Station 2 equipment that is not in that deed. The SCR, the scrubber, the stacks. In your far right, you'll see some green, some font that's in green there. Yes, that's it. So in that area, there's also flakers and items that belong to the city of Henderson, part of Station 2. Again, that's nowhere even near that property that Henderson tries to say, well, it reverts back to Big River, so they have no responsibility for decommissioning. So what we wanted to try to represent in is this equipment is spread out over a huge area, and it's not just one little piece that has the reversion language in it. So you can see that these things are intermingled across the entire site, which is why that it's been such a benefit to Henderson, why this has been such a good deal for Henderson all these years. They got to use all that property and all that equipment in that site at little to no cost. And now they're just trying to walk away and say they have no obligation for any of it. So,
Thank you, Mr. Berry. Mr. Nguyen, I think we're done with the exhibit unless you have questions.
No.
One last set of redirect. Did you recall a lot of extensive questions from council for the city about the excess Henderson Energy and the release and so forth?
yes,
Okay. First of all, excess Henderson Energy is the difference between, let's just make these, if they reserved 115 megawatts and their actual load was 100, that would mean there was 15 megawatts of excess Henderson Energy for that particular hour. Is that correct?
that's correct.
And for that particular hour, the revenues that could be received in the MISO market might be higher or lower than the cost of Station 2. Is that correct?
That's correct.
So for example, in July, the excess Henderson Energy might be profitable or wanted, but in May, it may be unprofitable or unwanted.
That's correct. And it can change by hour, not just by month.
And it's your position that the release covered all excess Henderson Energy, not just a subset.
That's correct. I specifically demanded that language that's in the contract, in the settlement agreement to be there, because I wanted it to cover all excess Henderson Energy so that there's no more litigation. There's been litigation for 20 years over excess Henderson Energy between LG&E and Big Rivers, paid twice to resolve those issues, and I just wanted to resolve it once and for all.
I want to just read you the release. It's a little bit lengthy, and then I just want to ask you a question on it. This is attached to Mr. Berry's direct testimony as Exhibit 1. This is the release that was referred to in the cross-examination. In consideration of the mutual promises, covenants, and agreements contained in this agreement, the resolution and settlement of disputed claims and controversies, and other good and valuable consideration, the receipt and sufficiency of which are conclusively acknowledged, Henderson hereby releases, acquits, and forever discharges individually and collectively Big Rivers and WKE, that's LG&E's unregulated affiliate, is that correct?
That's correct.
Okay. Along with their affiliates, parents, members, officers, directors, employees, agents, representatives, advisors, successors, predecessors, boards, and assigns, collectively the released parties, of and from any and all manner of actions, causes of actions, suits, sums of money, accountings, reckonings, covenants, controversies, agreements, promises, remedies, amount paid in settlement, compromises, losses, rights of contribution, damages, judgments, execution, debts, obligations, liabilities, claims, and demands of any nature or kind whatsoever, whether or not in contract, equity, in tort, or otherwise, which Henderson ever had, now has, may now have, or may hereafter have, against the released parties or any of them, resulting from, arising out of, or in any manner relating to the generation, production, use, sale, or resale of disputed excess energy as defined herein, or the capacity, fixed or variable costs associated with such energy, including but not limited to those asserted or that could have been asserted in, or that were or could have been in any way connected with the damages suits or the arbitration proceeding, and any obligations, past or future, of Big Rivers to Henderson under the power sales contract or the arbitration proceeding related to, arising out of or concerning disputed excess energy as defined herein, whether known or unknown, accrued or unaccrued, asserted or unasserted, direct or indirect, fixed, contingent, or otherwise, collectively referred to as the released claims. Just a little bit more. Henderson acknowledges that it may hereafter discover claims or facts in addition to or different from those currently known to Henderson with respect to the release and the released claims. Henderson hereby expressly assumes the risk of any mistake of fact and of any facts proven to be other than or different from the facts now known to any of the parties or believed by them to exist. Henderson intends to fully, finally, and forever settle and release all released claims, and in furtherance of such intention, this release shall be and remain in effect as a full and complete general release with respect to the released claims, notwithstanding the discovery or existence of any such additional or different claims or facts, end quote. When you paid the city of Henderson $6.25 million, was it your understanding that this release forever resolves the excess Henderson Energy, all claims before January 4th, 2018?
Yes.
Mr. Chairman, no more questions?
Thank you. Now, that normally would end the examination of Mr. Berry, but Mr. Redding, I want to give you one more opportunity, if you choose to cross-examine Mr. Berry only on the costs which he says, or which Big Rivers say, contributed to the higher utility rates, electricity rates for residential customers among his three rural electric cooperatives as opposed to the city of Henderson. In order to solve the issue about additional information from a data request, I'm going to direct staff counsel not to send a data request asking for this specific information. Henderson Big Rivers chose not to provide detailed information in the first place, and so there's no need for us to have that in any way to resolve this matter. So, Mr. Redding, would you like to ask Mr. Berry additional questions limited to those costs that he discussed on redirect as bearing on the difference in electricity rates?
No, Mr. Chairman.
Okay, thank you. All right, may this witness be excused? Mr. Redding,
Yes, Your Honor.
you may step down, Mr. Berry. Thank you.
Thank you.
Okay, Mr. Kurtz or Mr. Kamuth, please call your next witness.
Thank you, Your Honor. We would like to call Jeff Kopp. He's remote. He's the Burns McDonald witness.
Thank you.
Get-
Now, he's
Yes.
he's a remote witness, is that correct?
He is a direct and rebuttal witness.
Okay.
Who was that?
Oh, remote.
Chairman?
Yes, he's
I'm
remote.
sorry,
What was the name of the witness?
Jeffrey Kopp.
Kopp, Mr. Kopp.
Mr. Cobb. Thank you.
Okay, Mr. Kopp, is that you?
Yes, good morning.
Would you please raise your right hand? Do you solemnly swear or affirm under penalty of perjury that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Mr. Kurtz, you may ask.
We say your name and business record, business title for the record.
Yes, my name is Jeffrey E. Kopp. I go by Jeff. I'm the manager of our utility consulting department in our 1898 and Co. division of Burns and McDonald Engineering Company.
Did you cause to be filed direct and rebuttal testimony?
Yes, I did.
Was it prepared by you or under your direct supervision?
Yes, it was.
If I were to ask you the same questions as those contained therein, would your answers be the same?
Yes, they would.
Any corrections or additions you'd like to make?
One minor correction, in my testimony, I was listed as working in the Business and Technology Solutions Division, and we have renamed that division to 1898 and Co.
Chairman, we tender the witness for cross-examination.
Thank you. Mr. Redding, cross-examination.
Randall Redding for Henderson Municipal Fire and Light. You're not offering any testimony as to the fee simple or title ownership to the Station 2 plant or the cooling towers, are you?
I am not.
That's all.
Okay, thank you. Mr. Nguyen, questions?
No questions, Your Honor.
Commissioner Matthews, questions?
I don't have any questions.
I have none either, so may Mr. Kopp be excused?
Yes, sir.
You're excused, Mr. Kopp. You probably got the benefit of being the shortest witness that we've ever
Wow.
had here before the Public Service Commission. So thank you.
All right, thank you.
You're excused. Mr. Kurtz, you care to call another witness?
Yes, sir. We call Michael Pullen.
Please raise your right hand. Do you solemnly swear or affirm under penalty of perjury that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Mr. Kurtz, you may ask.
Will you state your name and business address or business title for the record, please?
It's Michael T. Pullen, Executive Vice President Operations for Big Rivers Electric.
Did you file direct and rebuttal testimony in this case?
I did.
If I were to ask you the same questions as those contained therein, would your answer be the same?
I do have some changes.
Okay.
Okay, so first off, regarding the grain landfill cost sharing percentages that Mr. Reddy asked Mr. Berry about earlier, discussing my testimony on page 18 of 23, and in the data response to HIMPL 1-63, I'd like to make a change. At the time, my testimony and data response was based on the actual quantities of material that were stored in the green landfill on a monthly basis for the time period from 1995 to 2019. And this is based on actual data reported monthly, known to both parties. This week, at HIMPL's request, they requested that Big Rivers estimate the amount of ash placed in the landfill prior to 1995, for which there is no data, but we are able to make some engineering calculations. To do that, I use the annual generation for each of the units at the Seacrest Station, Green 1, Green 2, Reed 1, Station 2, Units 1 and 2. I use the ash content for the fuel characteristics for the years that were available
For some of those years, the fuel characteristics was not available, so I substituted data from surrounding years, making the best estimate possible at the time. I assumed that all the fly ash and bottom ash from Reed 1, Station 2, and Green was placed in the landfill. So given all that, the calculations yielded the following changes. Henderson's share of ash that's currently stored in the Green landfill, we would calculate that to be 9.88% as opposed to 11.25% previously measured based on actual data. So there is some change, 9.88 compared to 11.25.
Can I stop you, Mr. Pullen? Is there a tonnage amount associated with 9.88%?
Yes. It's 2.853 million tons. But that's the city share.
Sorry, thank you. Continue.
We also, in my direct testament, only on page 18 and 23, lines 10 through 11, I indicated that we did not have closure costs estimated for the Green landfill. We have those costs today, estimated costs. It's based on the closure turf system, a synthetic system. Same system as we have planned for Wilson and was discussed in the environmental compliance plan recently approved by the commission for the phase 1 closure of the Wilson landfill. The least cost estimate solution is $20.7 million for closure of the Green landfill. We're now able to make a estimate because, as Mr. Berry earlier testified, we have a forecasted end date for generation for the Green units of June of 22. Henderson's share of that is estimated to be approximately $2 million based on the roughly 10% share of your waste in the landfill. And finally, the last change that I need to submit is regarding the Green Title V permit, was discussed in my rebuttal testimony on page 5, lines 15 through 18. The Green Title V permit was revised by the Kentucky Energy and Environment Cabinet on September 17th, 2020. The statement quoted in my rebuttal testimony from the executive summary was replaced with the following. It says now on February 1st, 2019, the Henderson Station 2 ceased operation. Those are the only changes I have.
Thank you, Mr. Pullen. Your Honor, the witness is ready for cross.
Okay. Mr. Redding, cross-examination?
Yes, Mr. Commissioner. Mr. Pullum, the statement that you amended on the green permitting was changed from a statement that Big Rivers had committed in there that the city of Henderson was the owner and operator of Station 2, correct?
That was not Big River's statement. That was the Energy and Environment Cabinet's statement. They're the ones that issued the permit. But we agreed to the change as it currently reads.
Because we recognize that the ownership of the Station 2 and the cooling towers under a legal pending lawsuit is in dispute. I'm aware there is a lawsuit in Webster County related to the reversion deed of Station 2 and some of the property that's owned by Station 2 by the city of Henderson. You gave Mr. Kurtz the denominator of what you estimated to believe the tonnage. What would the denominator be in your? So if you gave the numerator, the denominator be?
Yeah, I gave the numerator for the city share, which is $2.853 million or tons. The denominator for all the ash that's in Station 2 in the Green landfill is 28.862 million tons.
And that number, Big Rivers is continuing to use the its greenfield asset, is it not?
Yes, we continue to use it.
Continue to put green station waste in that landfill.
Yes.
And so the the lower number will continue to increase in this formula.
That is correct. Yes, the 9.88 reflects the percentage of ash that the city of Henderson owns in that landfill as of the end of 2019. It's Big River's position that as we incur costs to do maintenance related to the storage of that ash on an annual basis, the city should be responsible to pay their share of that storage as those costs are incurred based on the percentage of ash on an annual basis. So that's the percentage we know today for expenses incurred related to the storage of ash in 2020. We will update that number at the end of 2020, and then if we incur expenses related to the storage of the city's ash in 2021, that percentage will go down because the denominator goes up, as you explained.
There will be no more Station 2, irregardless of the percentages going into the land. There's no more after February of 2019.
Well, so we have not done the engineering, neither party's done the engineering to close that Station 2 ash pond. There still is bottom ash in the Station 2 ash pond that's from Station 2. Depending on the final closure and the groundwater monitoring that's going to go on for 30 years, if there's an impact to groundwater monitoring, there's a potential that bottom ash in the ash pond might eventually have to be removed from the ash pond. That might get put in the station, in the green landfill, and that would change the city's percentage.
But as we sit here with the proceedings today, since February of 2019, there's not been any Station 2 waste going into the Big River's green landfill asset.
We haven't put any in, yes, since the plant was shut down, there's not been any more put in there.
And Big River's charged Henderson a disposal fee up through 2019 for the waste coming out of the Station 2, did it not?
So what we did was, we have a third-party contractor that hauls the waste from the dewatering location at Green. It hauls that ash to the landfill. They place it in there, they maintain it, and operate that for us. So as Big Rivers incurred those costs, we passed those costs, as we incurred those, the exact cost to the city. We did not make any profit. We didn't charge any administrative fee. There's no profit at all. It's just we passed the cost to the city as we incurred those costs from the third-party contractor.
And the city of Henderson paid those costs to Big River, paid those bills.
Yeah, to the extent that, well, I hesitate to say they've been paid because it's my understanding that as part of this proceeding, there's still outstanding payments due related to some of the fiscal years. And Mr. Smith probably can answer that better than I can.
To your knowledge, though, any bill that was presented for the disposal was paid.
It was paid by Big Rivers, and it would have been accrued as part of the annual fiscal year settlement against the budget payments that were made by the city.
Thank you, Seth. May I have just a minute?
Yes, you may.
Can we move that? David, you know how to use that. That's all I have, Commissioner.
Thank you. Mr. Nguyen, questions?
Yes, Your Honor. Good Good morning, Mr. Pullen. Can you hear me okay?
Yes, I can.
Okay, great. Can you refer to your rebuttal testimony on page 5? This is regarding the new Title V operating permit for the Green Station.
Okay.
So the new permit was issued on July 12th, 2020, correct?
Well, but in my rebuttal correction, it was reissued on September 17, 2020.
Okay, that's correct. So what precipitated Big Rivers to try to obtain a new air permit for the Green Station?
So Big Rivers did not ask for a revision. The city of Henderson requested a hearing on the Green Title V permit after it was issued, and that precipitated this change that was made.
Okay. And you mentioned that in the executive summary, the language regarding the ownership of Station 2 being solely being the city of Henderson, as well as being the sole operator of Station 2. And you mentioned that that language was included by the Division of Air Quality and not by Big Rivers?
Yes, that was in the permit as issued by the Kentucky Division of Air Quality.
Okay. If you know, would you have any knowledge as to why that was included in by DAQ?
So when Station 2 was retired, prior to its retirement, Big Rivers and the city of Henderson sent a joint letter to the Division of Air Quality indicating that the Station 2 was going to be retired on February 1st and would no longer be in operation. Subsequent to that, they issued this statement in the permit based on that letter and their understanding of it. I think based on their understanding of the operation of Station 2 going forward, that Big Rivers was no longer the operator of Station 2 once the contracts between the city and Big Rivers had expired.
Okay. Does Station 2 have a Title V operating permit, or did it have a Title V operating permit as well?
It did.
Okay. And I take it that's no longer in effect?
It's, what's in process now is a revision to the permit to include a recombustion turbine, but the Station 2 units will no longer be on the operating air permit.
Do you know if there's any similar language in the Station 2 air permit regarding the city's ownership or an operation of Station 2?
There is not, because that permit precedes the retirement of Station 2, and it has not been reissued yet.
Okay. Not sure if it's been provided, but could you provide a copy of the Green Station Title V permit?
I will.
Okay. And would you also have access to the Station 2 Title V permit? Or
Yes, we do.
Okay. Could you request that to be provided as well?
I will.
Okay. Can you turn now to page 6 of your rebuttal?
Okay.
It's at the top of the page regarding the city of Henderson now being responsible for environmental compliance at Station 2 as a result of the new Title V operating permit for the Green Station. So you mentioned that you had written a letter to Ms. Heimgartner indicating that as well. So in addition to the letter that was written to Mr. Heimgartner and the new Title V air permit for the Green Station, are there any other steps that need to be taken to effectuate the shifting of the environmental compliance responsibility at Station 2 from Big Rivers to the city of Henderson?
The KPDS permit needs to be revised to shift responsibility for the Station 2 ash pond, to make it clear the city's the operator of the Station 2 ash pond and the associated outfalls.
And who's responsible for making that change? Which, the Big Rivers or the city?
So Big Rivers has submitted an application to make that change, but to have the change completed, the Kentucky Division of Water has indicated that the city must agree to accept that responsibility. And as of yet, the city has not agreed to accept the responsibility as the operator for the Station 2 ash pond and associated outfalls.
Okay. Any other steps that need to be taken?
Not that I can think of at this time.
Okay. So what would happen if the city does not accept responsibility to take over the compliance, environmental compliance responsibility with respect to the Station 2 ash pond?
So those responsibilities or those regulations fall under the Kentucky Division of Waste Management, Chapter 45 and Chapter 46 regulations. So could be subject to notice of violation and enforcement action by the state, as well as the ash pond closure is regulated under the federal CCR regulation, which is enforceable through civil action.
Well, I was asking more in terms of the change that's been requested by Big Rivers with respect to the permit related to Station 2, to have the city assume responsibility for compliance with respect to the Station 2 ash pond. And you mentioned that the city at this time has not yet agreed to accept responsibility. Is that correct?
That is correct.
Okay, so to the extent that if the city doesn't agree to accept responsibility, what happens to that permit? Or that request to revise the permit?
I probably would need to refer that to our council, but I believe Big Rivers would be required to take some sort of legal suit to compel the city to take on that responsibility.
Okay. And short of having to make that, needing to make that change, would Big River still be responsible for the compliance, environmental compliance with respect to the Station 2 ash pond, and therefore any penalties that may result from any non-compliance?
So Big Rivers, as the operator on the KPDS permit, we're continuing to comply with those requirements because as the operator on that, we are liable for that. For the ash pond closure, those regulations apply to the owner and the operator. So the city is the owner and operator of the ash pond itself. So that in our position, that liability lies with the city.
Okay. So the change in the permit for Station 2, the operation of the Station 2 ash pond would not impact who's would be obligated, which entity would be obligated for any non-compliance penalties. Is that what you're saying? Well, let me restate that. The requested change in the permit for the Station 2 ash pond, to the extent that the city does not accept responsibility does not accept responsibility for that change. Any future potential non-compliance with the CCR rule, the penalties associated with any of those non-compliance would then be obligated to the owner, which would be the city. Is that correct?
Yeah, the CCR rule applies to the owner and the operator. The city is clearly the owner of Station 2. Big River's responsibility as the operator ended at the end of the Station 2 contracts when they terminated in 2019. So by default, as the owner, the city is the operator of the Station 2 ash pond as well. Big Rivers is the operator on the KPDS permit, which includes the Station 2 ash pond. So there is, I guess, some ambiguity there. And it'd be a concern on ours that we could potentially be responsible for enforcement action if this doesn't get resolved properly and clearly.
Okay. Can you look down on lines 8 through 11 of your, on the same page, page 6 of your rebuttal testimony? You discussed the recent filing by the City of Henderson in Webster Circuit Court regarding the decommissioning costs of the Station 2 ash pond.
Okay.
Does Big Rivers have a copy of that complaint?
Yes. Yes, we do.
Could I request a copy of that complaint as part of a post-hearing data request?
Okay. That's the May 2020 complaint in the Webster Circuit Court.
Regarding the decommission cost allocation between the city and Big Rivers.
For the Station 2 ash pond, yes.
Could you turn to page 7 of your rebuttal testimony now?
Okay.
And lines 12 through 14.
Okay.
Similar question was asked of Mr. Berry, but you also provided the same type of statement in terms of to the fact that Big Rivers would have no contractual obligations to share in any retirement and place costs associated with the decommissioning of Station 2. Could you provide some additional details or support for this particular statement?
Yes, so the 1993 amendments provided that Big Rivers would share in the decommissioning of Station 2 if Big Rivers chose to extend the contracts for the life of the plant. Prior to that, Big Rivers did not have an obligation to pay for decommissioning of Station 2 in the contracts. Of course, the contracts were extended through the life of the plant. So we have a decommissioning responsibility of approximately 78%, but we do not have responsibility to pay for the units to sit in a retired in place situation indefinitely. The contract language clearly addresses decommissioning, not retirement in place.
Okay, so so your position is that the term decommissioning, as it's mentioned in the in the Station 2 contracts refers only to the full retirement, the complete demolition and remediation of the facilities, and not a retirement in place scenario?
Yes, that's what we believe the decommissioning was meant to be, would be to the final retirement and disposition of the units to bring them back to a brownfield state. As we've said in our testimony that Mr. Kopp and I have as well, after about 5 to 7 years, you're going to spend as much money keeping a unit in a retired in place condition is what it would to eventually dismantle the unit and do that. And, common sense tells us you can't leave those units, those structures standing there forever. They're going to deteriorate. They're next to other operating units. The Reed combustion turbines, it's directly adjacent to the Station 2 units. Based on our experience at Coleman, we know that as time goes on, structures deteriorate, and it just doesn't make sense to leave a unit indefinitely like that. Eventually, it's going to have to come down. So Big Rivers doesn't understand, or we don't think we're responsible for leaving the unit just sitting there and retired in place indefinitely. We're fully prepared to pay our 78% of decommissioning and dismantling the units and returning them to the brownfield condition.
But is it ultimately the city's decision with respect to that?
It is. They're the owner.
And you mentioned the 5 to 7 years range with respect to retirement in place costs outstripping the cost to fully retire the station. Was that 5 to 7 years range based upon the original estimated cost to fully decommission Station 2, and not based upon I would say that the cost that was mentioned earlier by Mr. Berry, which was much less?
Yeah, so just let's talk about kind of numbers that Big Rivers knows. We spent to keep Coleman idled, which are similar units. There's 3 units at Coleman, 2 at Station 2, but they're essentially the same units. We spent in the range of $1 million a year initially to keep it idled, similar to a dry, dark, and safe condition at Station 2. Now that cost did go down over the years. We now know, based on the bids that we've gotten to dismantle the Coleman units, that's $3 to $6 million. So, I think based on the information that I have today from Coleman and its applicability to Station 2, I think a 5 to 7 year payback seems like a reasonable estimate to me.
Okay. And you mentioned that the annual costs associated with idling the station versus the annual cost to keep it in a dry, safe, and dark situation is roughly the same. Is that correct?
Yeah, to keep it idle is more expensive because we had dehumidifiers on the units at Coleman because we anticipated restarting that. So we had more people on site doing testing, rotating equipment, maintaining those dehumidifiers. But I would also point that you go back and look at the city's IRP, I believe they did in 2017. Their consultant estimated $775,000 a year to keep the unit in a retired in place condition. So, it's in the ballpark of what we saw at Coleman.
Okay. Those are all the questions I have. Thank you.
Commissioner Matthews, questions?
I don't have any questions.
Neither do I. Mr. Kurtz, redirect.
Yes, sir, thank you. Mr. Cullen, compliance with the CCR rule at the Station 2 ash pond is a legal requirement, correct?
Yes.
And what is your best estimate of the cost to close, decommission the Station 2 ash pond consistent with the CCR rule.
Yeah, so the total cost is estimated at $13.3 million.
It's correct, isn't it, that the ash pond is included in the definition of Station 2? The ash pond is part of Station 2, just like the boilers and chimneys and the turbines, et cetera. So if the decommissioning cost percentage applied to the ash pond, the city share would be approximately $3 million.
Yes.
In order to comply with federal law and to avoid these civil and criminal penalties, which could arise as to somebody, is Big Rivers prepared to decommission the Station 2 ash pond, provided that the city pays its 22.76% of the decommissioning costs?
Yes, we've gotten authority from the PSC to spend that money to decommission it. We've got proposals from engineering companies to do the final engineering design for the closure. We just need to have the agreement from the city on we're going to each pay our share, and we're prepared to move forward.
Mr. Chairman, no further questions?
May this witness be excused?
Yes, Your Honor.
I assume that
Follow
you may step down.
Mr.
Yes.
Chairman, may I ask a question?
Well, you want to ask a question of the witness?
Yes, Your Honor. Yes, sir.
All right. Normally, I'd say no, but let's go ahead and ask a question.
I don't think these are relatively. Mr. Polo, as a follow-up to what Mr. Nguyen has asked you, can you also provide in your supplemental data request regarding the application for the green permit, the filings that Big Rivers filed for the application addressing the air quality green permit that Mr. Nguyen asked you to address?
So Mr. Glenn, I assume we're going to get it in writing. What I understand, he didn't ask for the application. He asked for the permit as issued on September 17th of 2020.
That's correct.
So you're going to provide the information of which the cabinet relied upon for their statement that we talked about?
No, he asked for the permit as issued. It's a public document, but we're happy to provide it.
Can you provide the application that Big Rivers sent to the cabinet?
We have an application. We can provide it, yes.
Did you say yes, you would?
Yes.
And the ash pond is a joint use facility asset?
It's a city-owned joint use facility, yes.
Thank you, sir.
Is that all you have, Mr. Redding?
Yes, sir.
So you'll need to, at the close of all the testimony, the parties will discuss the time needed to draft and respond to these data requests, which are really just interrogatories. So you'll need to, at some point, we'll talk about, you'll need to file a data request into the record and serve it upon Big Rivers in order to get that information. I will also say this. This is a contested proceeding between two parties, and so data requests, including data requests from staff, are going to be limited to documents such as permits and other things other than evidence. We're not going to entertain any additional evidence or explanation by way of a data request, because it deprives the other party, whichever party it is, of an opportunity to cross-examine or basically to contest it. So the data request will be limited to documents. All right, Mr. Kurtz, you have another witness?
Yes, we do. Mr. Chambliss?
Will you please raise your right hand? Do you solemnly swear or affirm under penalty of perjury that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you. Mr. Kurtz?
Will you state your name and business address for the record, please?
My name is Michael W. Chambliss. I go by Mike. Business address is 201 3rd Street, Henderson, Kentucky, 42420.
And your title?
Vice President of System Operations for Big Rivers Electric.
Did you prepare direct and rebuttal testimony in this case?
Yes, I,
If I were to ask you the same questions, would your answers be the same?
yes, they will.
Any corrections or additions?
No, sir.
Your Honor, the witness is ready for cross.
Okay, Mr. Redding, cross-examination.
We have no questions of this witness.
Mr. Nguyen, questions?
Just one quick question, Your Honor, more of a clarification than anything else. Good morning, Mr. Chambliss.
Good morning.
Could you refer to page 3 of your rebuttal testimony? The response at the bottom of the page, lines 15 through 19.
All right, page 3, lines 15 through 19, is that correct?
Yes, sir. The response, well, the question at, above this response refers to the direct testimony of Mr. Bickett regarding the power sales contract and the systems reserves agreement being entered into prior to joining MISO, and that neither of those amendments were amended to address a transition to MISO. And then your response to the question of whether or not you agree with Mr. Bickett's statement was no. And you mentioned that the system reserves amendment was amended in 1998 to specifically address RTO such as MISO. Is that correct?
Yes, sir.
Okay, and then you also say that since the system reserve agreement already had a provision to recognize a RTO such as MISO, it required no additional amendment, as Mr. Bickett implies. Is that second reference to the system reserves agreement, was that meant to be reference to the power sales agreement?
No, sir, it was the Systems Reserves Agreement as it was amended in 1998.
Okay, okay. And what about the power sales agreement? Did that already contain language regarding the recognition of a RTO such as MISO in the power sales agreement?
I apologize, I don't have sufficient knowledge to answer that question.
Okay, okay. Those are all the questions I have. Thank you, Your Honor.
Commissioner Matthews, questions?
I don't have any, thanks.
I have no questions. Mr. Kurtz, any redirect?
Very, very briefly, Mr. Chambliss, staff counsel Wynn asked you about the system reserves agreement and its anticipation of MISO, essentially. Is this the provision, page 10 of the 1998 amendments?
Yes, sir, it is. Section 2.1 on page 10 was amended in 1998. Originally, Section 2.1 addressed specifically planning reserve margin. In 1998, 2.1, the scope of what that addressed was significantly expanded to cover not only planning reserves, but all reserves on the system. And specifically, any regional transmission authority was placed in Section 2.1.
Would that include MISO?
Yes, of course, whenever this was negotiated or added, LG&E
was a party to the original amendment. LG&E was one of the founding transmission owners in the MISO. So MISO was being stood up in that time frame, and so LG&E was aware well of that and addressed that with this language of regional transmission authority.
Mr. Chairman, no additional questions.
May this witness be excused? Mr. Chambliss, you may be excused. Thank you.
Thank you, Your Honor.
It's, I guess it's 20 minutes till noon. Mr. Kurtz, is there a short witness that you think we may, I guess that depends on Mr. Reddick more than anything else. But,
We have
let's see if we
two.
can call and get another one started anyway.
Would you like us to do that?
Yeah, let's put on, try to get one more witness.
Okay. Mr. Akrit?
Who did you say?
Mark Ekrit.
Egret.
Mr. Ekrit, would you please raise your right hand? Do you solemnly swear or affirm under penalty of perjury that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Mr. Kurtz, you may ask.
Would you state your name and business address for the record, please?
Mark Akert, 201 3rd Street, Henderson, Kentucky.
Did you prepare direct and rebuttal testimony?
Yes.
If I were to ask you the same questions, would your answer be the same?
Yes.
Any corrections or additions?
No.
Your Honor, the witness is ready for cross.
Okay, Mr. Redding?
We have no questions of this witness.
Mr. Nguyen, questions?
Just one question, Your Honor. Good morning, Mr. Ekrit.
Morning.
In the financial disputes portion of this case, Big Rivers is also requesting interest in addition to the cost that it says that it is entitled to from the city of Henderson. Is that correct?
Yes.
Okay. And there's a statement in your rebuttal testimony at page 9 of 12 regarding specifically interest on the MISO fees. And you state that interest is needed to make Big Rivers whole. Do you recall making that statement in your rebuttal testimony?
Yes.
Okay. Can you explain why interest is needed in order to make Big Rivers whole?
Our members have been bearing costs directly attributable to Henderson load and transmission for 6+ years, and bearing the carrying costs of those expenses. And so it seems equitable that our members should be compensated for that.
Okay. Those are all the questions I have.
Commissioner Matthews? Commissioner Matthews, any questions?
Sorry, you would think I would figure out the mute button by now. I do not have any, thank you.
I have no questions. Mr. Kurtz, redirect.
No redirect.
May this witness be excused? I assume so. You may step down, sir.
Thank you.
Now, Mr. Redding, I'm going to leave it up to you, since it's your cross-examination. I don't know how long your cross will be. There's one more witness, is that correct, Mr. Kurtz?
Yes.
And is that Mr. Smith?
Yes, sir.
And I'm always hesitant to interrupt an examination or a cross-examination to break for lunch, but we're going to do that at noon. So if, Mr. Redding, if you tell me you have a short cross, we'll go ahead and complete this witness. If you think it may take some time or take more than 15 or 20 minutes, we probably ought to just go ahead and break for lunch. If we complete if we finish with this witness, then you'll be putting on proof, I guess, at 1 o'clock.
I'm not anticipating any questions of Mr. Smith.
All right. Okay, then, let's go ahead and put Mr. Smith, get Mr. Smith's testimony. Okay, Mr. Smith, please raise your right hand. Do you solemnly swear or affirm under penalty of perjury that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
You may ask.
Will you please state your name and business address for the record, please?
Yes, my name is Paul Smith. My business address is 201 3rd Street, Henderson, Kentucky, 42420.
And your title?
I am the Chief Financial Officer for Big Rivers.
Did you prepare direct and rebuttal testimony?
I did.
Do you have any corrections or additions you'd like to make to your testimony?
I do.
Please.
First, a correction. It was mentioned previously by Mr. Barry, Mr. Poland, about a change in the Hempel allocation of the landfill to 9.88%. I have not done the calculation, but that would impact the amount owed by Hempel as of June 30th, 2020, by approximately $80,000. I also have two typographical corrections. First, to my direct testimony, page 6 of 19, on line 7, reference to the previous case that's been discussed this morning. That case number on line 7, it says it's 2018-00. The actual case number was 2016-00278. One other typographical correction on my rebuttal testimony, page 29 of 30, line 8. The first word on that line is refuses. The R was missing. It says efuses. So the sentence should read, beginning on line 8, if Henderson refuses to comply with the commission's lawful order by not paying its invoice for its share of Station 2 costs, then the commission should seek to compel obedience to its rate order at the Franklin Circuit Court pursuant to KRS 278.390. That's
Exactly. Chairman Schmidt, would you prefer or would you entertain an amended schedule from Mr. Smith showing that $80,000 correction?
That correction works to the advantage of Henderson, is that correct?
That's correct.
Yes. Yeah, unless, Mr. Reddick, I assume, wouldn't object. So, if he does, we're going to go ahead and let you put it in anyway, if you go ahead and file that. Post hearing, I suppose, is that, you would, are you prepared to file something now or after the case is after we finish the testimony?
I think after the case, I don't think it's prepared now, or is it?
It's not yet available, but can be shortly.
Okay. When you say shortly, what do you mean shortly? Today?
Within a day, certainly within a day.
That just file, well, you can just file it, we'll take it up at the end, but you can file it as, because we'll have a briefing schedule and data requests, so that'll be fine. You can file it along with the data requests, if you'd like, your responses. Mr. Redding, you have a cross-examination of this witness?
Just briefly, Mr. Randall Redding for Hempel, Mr. Smith, your calculations as presented in your direct and rebuttal testimony are based upon Big River's position in this case, are they not?
They're based on Big River's books and records, which reflect all documents available to Big Rivers and our interpretation thereof, yes.
It's based upon your interpretation. You understand that Henderson has a different interpretation that would drastically change the calculation.
Many different interpretations, yes, I'm aware.
And in your testimony, you asked the commission in relation to your calculations to not look back prior to January the 5th of 2018 in relation to your calculations.
I think to say differently, I would say that issues regarding excess Henderson energy and the totality of the excess Henderson energy was resolved in the December 2017 settlement agreement
and therefore there are no amounts prior to January 4th, 2018 that are relevant or payable by either party.
My question to you though, in your file testimony, on rebuttal testimony, page 3 of 30, you're asking the commission to not reach back to the time period prior to January 5th of 2018 in regards to my calculations.
That is correct.
All right. And the Franklin Circuit Court, if you know this, Big Rivers has also asked the Franklin Circuit Court to assess variable cost damages to Henderson in an amount of approximately $10 million. Are you aware of that?
I had no familiarity with that.
But by not looking back prior to 2018, in exchange for what Mr. Berry said was 6.25 that he don't pay, Big Rivers would keep $10 million in revenue for uneconomic excess energy. They would keep $2 million for profitable energy, and they would be reimbursed their variable costs for that energy that would be then pushed off to Henderson, correct?
No, I would probably disagree with all three of those.
Under your scenario, well, let's go through it again. Under the scenario that you are representing, if the Franklin Circuit Court awards variable costs to Henderson in the amount of $10 million, they would be paid to Big Rivers, correct?
Again, I'm not familiar with that. If the court so approved it, then we would certainly feel obligated, but I'm not familiar with that calculation.
And you do know that the revenue you receive from the disputed energy, for the unwanted, unprofitable energy from June of 16 to 2017, the revenue under your data request, page 101, witness response, was $10.69 million.
Yeah, we would need to be careful with mixing revenues with expenses. So there was approximately $10 million of revenue. There was also an offset of about $8 million of Big Rivers costs, and neither of those amounts would include the Henderson variable costs. So in total, I think the total expenses probably or likely did exceed the $10 million. But roughly, Big Rivers variable costs exceeded $8 million.
And the reason is because Big Rivers used Henderson's coal, so not only would Henderson have to pay the variable cost against this unprofitable $10 million, they'd have to write off their coal.
I would disagree. They had used Henderson's coal to the extent that it existed, but there was not sufficient coal to generate all of that excess Henderson in totality. So thus, the Big Rivers coal was used for both excess Henderson energy and the native load to serve the citizens of Henderson. So I would say it was by both parties.
But during that time period, Big Rivers used all of Henderson's coal and lime that was available.
If there was any available, the excess Henderson energy that was generated for the benefit of the city of Henderson used Henderson coal, as it correctly should.
And when you reference the unwanted Henderson energy, that is energy that the variable cost exceeded the revenues that it could generate.
So where did I reference unwanted energy? I don't remember that reference either in my testimony or...
Well, let's not look for it. Do you understand and agree with me that the unwanted energy is that energy that it costs more to produce than you can get revenues for?
Well, just a recollection, the city of Henderson required that Station 2 continue to operate when it was uneconomic. And again, I would call it a common utility practice of economic dispatch that the unit should not have generated it. So the fact that Henderson wanted Station 2 to generate that energy, I don't know that I would call it unwanted because the city of Henderson wanted it, obviously.
Well, let's redefine it. Let's start over again. Would you agree that uneconomic uneconomic energy is that energy that it costs more to produce than you can receive revenues for?
That would be uneconomic. I would agree with that.
Thank you. That's all we have.
Mr. Nguyen, questions?
Yes, Your Honor, thank you. Good morning, Mr. Smith. Just a couple of questions. Can you refer to your rebuttal testimony, page 8? And specifically lines 9 through 12, where you address Ms. Mall's testimony, particularly Exhibit Mall-2. Do you see that?
Yes.
Okay.
I
You state that Exhibit Mall-2 didn't set forth amounts that related solely to the excess Henderson energy, but also included fuel and reagents provided by Big Rivers to generate the energy needed to serve Henderson's native load. From the Exhibit Mall-2, could you provide a breakout of the amount of fuel and reagents that were used to serve Henderson's native load, and those amounts related to the excess Henderson energy? And I guess, is that shown by chance in your Exhibit Smith-3 to your direct testimony?
You're exactly correct. Smith Exhibit 3 is the native load component.
Okay.
That Moll's exhibit, which I believe is only a partial reproduction of that page that was attached to a settlement agreement by Mr. Berry. But it's only a partial representation. But that data is contained, and the native load component is contained in my Smith Exhibit 3. That's correct.
So if we take your Exhibit Smith-3 and net that from the Exhibit Mall-2, we'll have the fuel and reagents associated with the excess Henderson energy?
That's correct. And then subtracting what is in Smith Exhibit 2, then we give you the piece prior to January of 2018.
Okay. Thank you for that clarification. And also turn to your rebuttal testimony, beginning at the bottom of page 11. Regarding the Green Station landfill expansion. You address Ms. Mall's testimony regarding the city's lack of awareness of that plan. And you mentioned at the top of page 12 that, that you had knowledge that Henderson employees, Mr. Wayne Thompson, Mr. Gary Quick, and Mr. Ken Brooks were all very familiar with that green landfill expansion project. Is that correct?
Yes, that's correct.
Okay. Do you know what positions or what titles, what job titles these three individuals held at Henderson?
I do not, but I believe Mr. Thompson and Mr. Quick were, Mr. Quick was general manager. I believe Mr. Thompson and Mr. Brooks may have had similar production-related job responsibilities at Hempel. So they would have had hands-on knowledge of what was happening at Station 2 in the Seagrave facility. I'm not sure the financial group necessarily had that.
Okay. And how did you know that these individuals were very familiar with the landfill expansion project at the Green Station?
We had a conversation. I was aware that Henderson, when the vertical wall, expansion wall was being contemplated, had talked about the remaining useful life of Station 2. And at that time, they were estimating many, many years remaining in Station 2 of useful life of Station 2. And therefore, there was a need to expand the green landfill. And based on their assertions of how long Station 2 would continue to operate, that was why we needed to vertical wall expansion, or the least economic alternative to store the ash and the residuals.
So was this close in, was their knowledge of the expansion project close in time to when the project was actually implemented?
Absolutely.
Okay.
Yep. Mr. Thompson was, I think, only employed until about that point in time.
Okay. Those are all the questions I have. Thank you, Your Honor.
Commissioner Matthews, questions?
I don't have any.
I have none. Mr. Kurtz, redirect.
No redirect.
All right, may this witness be excused? All right, you may be excused, Mr. Smith. Mr. Kurtz, do you have other witnesses, or is this the case for Big Rivers?
Mr. Chairman, that's Big River's case.
All right, let's take a lunch break until 1 o'clock, and when we come back, Mr. Redding, will you be ready to present evidence?
Yes.
I couldn't hear you, but I assume that you will be.
Yes.
So we'll be in recess until 1 o'clock. We're now back on the record. Mr. Redding, on behalf of the City of Henderson and its Utility Commission, do you have a witness to call?
We do, Mr. Commissioner. We would call Barbara Mall.
Oh, is she with you there, Mr. Redding? Oh,
She
okay,
is,
I see
Your Honor.
now, I'm sorry. I apologize, I didn't understand. Ms. Small, will you please raise your right hand? Do you solemnly swear or affirm under penalty of perjury that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
You'll probably need to
Ms.
speak
Mall.
up. You probably need to speak up, Ms. Mall. It may be hard to hear you.
Okay. Ms. Mall, on behalf of Henderson Municipal Fire Life, would you state your name?
Barbara Mall,
And what is your business position?
Chief Financial Officer for Henderson Municipal Power and Light,
What is your business address?
105th Street, Henderson, Kentucky, 42420.
And do you adopt, you file direct testimony in this action, including an amended testimony?
Yes,
And do you adopt that,
yes,
including the exhibits that are attached both to your original testimony or amended testimony?
yes.
Do you have any clarifications or corrections that you want?
I just wanted to point out that in my amended testimony, I did make a correction related to severance costs for an amount that was double counted. So my amended testimony and the exhibits have been corrected for that error.
With that, we turn the witness over to the parties.
Mr. Kamuth, Mr. Kurtz, any cross-examination?
Yes, Your Honor, a little bit, just on severance. Ms. Mulga, good afternoon.
Yeah,
Okay, on page 8 of your testimony, lines 14, 15, and line 21, you assert that Big Rivers charged the city severance costs without any contractual authority to do so. Do you see that?
yes.
First of all, put the severance in perspective. What was the total amount of severance that Big Rivers paid the employees?
I believe that was 3.3 million.
I thought it wasn't it reduced to the later debt response?
Yes, it was reduced by the, it was 143,000 for Kimball portion.
So, and do you know that how many employees that covered?
I believe it was 62.
Okay. And is it your understanding that that was about $50,000 per employee, which was 6 months of compensation, including health insurance?
Yes, in summary, I have said 6 months at approximately 38.78 per hour, and that was 6 months of pay per severed employee.
Okay. And it's your position that was a non-contract, that under the contracts, Big Rivers was not authorized to make that severance payment, correct?
Yes.
I'm sorry? Is that a yes?
Yes.
Are you familiar with the power plant construction and operation agreement?
I know it exists. I've read portions of it.
Have you read section 13.4, which states, Big Rivers covenants and agrees that during the term of this agreement, it will at all times operate cities Station 2 on the best efforts basis in an efficient and economical manner, and will maintain, preserve, and keep said Station 2 and every part thereof in good repair. And then section 13.6 goes on to say, city will pay Big Rivers on a monthly basis its reasonable expenditures incurred in the operation and maintenance of City Station 2. Are you familiar with those provisions?
I think their phone disconnected.
Quan, is the city still connected by phone?
Chairman?
I'm sorry. Can,
Oh, we think the city we might have lost contact.
yeah, I see the city, but I don't see,
We don't hear him.
Mr. Redding, can you hear?
He's calling, so.
It's not showing up.
Hello? Okay, let us check it out.
Does that keep working for you guys?
It appears that the city is unable to hear the hearing, and we're unable to hear them as well. So, not sure if it's on our side or if it's on their side.
We can see the city, but they can't see us, and they can't hear us. So, there has